Hi, it's Tony again from Estate Planning Solutions, doing another video on giving you information so that you can make sure that your will and estate planning is done properly. Last week we covered the ground of some very well-known high-profile people who had trusted advisors and trusted associated professionals, and we demonstrated that they were actually incompetent in putting the wills together because the three cases we used are all being challenged. These some of the paper articles that appeared. This is the one on Neville Wran's family, Richie Benaud's family challenging the estate, King Bart Cummings. It's another article here where our Superannuation Complaints Tribunal in Australia is a mess. We won't cover that today. That'll be another topic. And one that a lot of people are not aware of, which is disgraceful, is that carers are now making claims on people's wills. So the people entrusted with looking after our old and our frail are also putting their hand up. Today we're going to look at one of the triggers of will challenge. There's about 13, but today we're just going to focus on one, and this is a reminder that to get your will and estate planning done properly, you need to make it challenge proof, you need to find the right people, you need to see specialists, because your general practitioner lawyer, your public trustee, your online will, your news agency will, they just won't cut it in today's world. So the example we're going to use is one of a broken family that somebody's doing they're redoing their will. Probably the way to understand it from the start is that rules. We all operate by rules, whether it be at work, or whether it be with the road or life. You know, if we break the rules, we've got to suffer the consequences. So why is it, if you want to go to a lawyer or public trustee to get your will done, that it gets done, but they've got access to the same set of rules to the lawyers who can undo the will down the track if somebody wants to challenge the estate? So it just proves one thing, that the ones putting it together, you've got to be careful who you choose, because if you're choosing the ones that haven't got the full knowledge, you've already got the team of other ones who have the full knowledge and making bucket loads of money because they know that the will hasn't been put together in the first place unless it's been done by themselves or one of their colleagues. So there's the problem, but you're the meat in the sandwich because you don't know where to go to, you don't know how to construct it. At the end of the day, you want to make sure your will is challenge proof. So the example I'm going to use is a family that's broken down. A long-term marriage breaks down. There's young kids involved. There's obviously assets. There's legal procedures. There's settlement and all the stuff. So that happens, and then you might meet, or that person might meet, the partner of their dreams, the person they wish they'd been with forever. Fall madly in love, trust them implicitly, and want to live the rest of their life together with them. And that's what happens. And if it hasn't happened in your family, I'm sure you know someone's family that it has happened. So then they decide they're going to redo their will. Straight away there's a dynamic that comes into play, that if the other partner's got children as well, you have created a blended family. That creates its own issues, especially when you're preparing your will. So you might have in your mind that I trust this person implicitly and I know they'll do the right thing by my children. So what I'm going to do is I'm going to leave all my assets to them, all my proceeds of super, all my proceeds of life insurance, and we'll have a chat about what I want them to do for the kids, to continue their education, and make sure they're okay. So go ahead and the will gets constructed. The only problem is that if it's not constructed by the right people, an automatic trigger is going to come into play. You've actually probably broken a rule. And the rule is under this thing called proper provision, whereby the will maker must take into effect the family dynamics, and that is something that's horribly overlooked, and something that people get a bee in their bonnet about. Say, well, I'm over the ex-spouse, she's not getting anything, and I will dictate as to where my money goes, and again, that can be done, provided you get the right people to do it. But in the main, it's not being done properly. So let's say you've done your will, and you then slip off the planet, and all your proceeds of your estate end up in the hands of your new spouse as per what you wanted. However, the ex-spouse decides to raise their head and say, hang on a minute, I don't think he's made or she's made proper provision for me or the kids. Even though in your head you'd said, oh, well, my new spouse is going to be the one who's going to be in charge of all the funds, and I trust them and they'll do the right thing. Doesn't matter. So this is where the care has got to be taken, because so many court cases, and we're going to cover a few of them, and I'll send you to websites so you can download them and read them. So many court cases which are based on what's called proper provision. So there are things in this Succession Act, which is what the rules are, which specify that an eligible person can put up their hand for a claim. And while it's hard to believe, but an ex-spouse, one you've actually had a financial settlement with, is actually an eligible person, which means that you've got to, as the will maker, take into account their needs, especially if you've provided for them in the past. And you must also make sure that you provide for the children, even though you think you have, because you've given it to your ex-spouse to look after. So it becomes quite complicated because of the fact that people putting together the will for you in the main haven't got a clue about this sort of stuff. They don't question you when you go in, because you go in there to get your will done and you say, I want A, B, C, D and E, and 9 times out of 10 if you interview a lawyer, they'll say to you, oh, I act on instructions. So the client comes in and you instruct them to do things. But the smart one, or the one who's properly trained or is a specialist in this area, won't just do that. They're actually going to dig deep into your family dynamics of the complications, blended family, children on both sides, what you want to do, how you need to avoid a challenge, and they'll question you on that so that it give you some thinking to do before you actually put the will together. So just something simple like wanting to have your new spouse take charge of funds because you trust them. There's more to it than that. So that's food for thought, and next week we'll cover another issue that hopefully you find interesting.